Deputy International Relations Minister Alvin has appealed for financial assistance to help repatriate the bodies of foreign nationals who've sadly died in that devastating George building collapse. Representatives from the High Commission of Zimbabwe and Malawi are also in George to meet with family members of the victims and oversee the repatriation process. According to the Deputy Minister, repatriation is actually not covered by consular support services offered by the International Relations Department. Let's unpack now strategies for handling the employment situation when a worker is injured whilst on duty, as may be the case in this disaster. And for that, we're joined by Galeboe Modisapodi, who's an ER consultant and Molatudi attorneys and Molatudi advisory services. Great to have you on the program, sir. Thanks very much indeed for making time to speak to us. So much has happened since the situation in George began unfolding, and there are still so many unanswered questions. As a start, I wonder what comes up for you insofar as labor relations are concerned when you look at the situation in George.
Well, there's a number of challenges that come up. The first one is the scope of the law. South African law clearly defines an employee, and it will then define any person who does work for another as an employee. So one of the interesting questions that comes up here is, does that apply to foreign nationals? And I think if you look at jurisprudence from a number of other areas, our constitution has permitted the inclusion of foreign nationals in terms of certain benefits, particularly when it comes to matters of immigration. So in this instance, it will be interesting to see how that unfolds in regard to coverage in terms of COIDA, amongst other legislation.
But at least there must be some kind of, legal precept or legal steps that need to be taken even before the foreign nationals can legally begin the work on this construction site. I mean, I found it very interesting, for example, that police are telling us that there's outstanding documents that make it difficult to even identify these individuals at that site.
That's true. I think one of the challenges we have, particularly with employers sometimes, I think this is more prevalent in the restaurant industries and a number of others, where there's somewhat of a preference in some instances to employ foreign nationals without documentation on the premise that you will be able to pay them less than you would pay South Africans. I think the law is very clear on that. So as an employer, you are obligated to ensure that your employees have the right paperwork. So if they don't have the right paperwork, it does not exonerate you as an employer. You still have liability because the obligation is on you to make sure that employees have the right set of paperwork.
Yeah, I mean...
And what...
Please continue. Apologies.
Go ahead. No, I'm saying what you also have as well is that the legal obligation on an employer is to ensure a safe working environment. And that presupposes whoever is at your premises, firstly, they will have the right documentation. And secondly, you will then discharge your responsibility as an employer to ensure that we have a safe working environment. So when issues come up of missing paperwork, I think it's a matter that at some point the employers are going to have to answer to when the Department of Labor and the inspectors just do their due diligence investigations.
Absolutely. And it's not just, the labor laws that we're worried about, but if you, for example, having people work at the site who are not necessarily there legally, you, A, underpaying them, possibly, as you've already mentioned, but B, you're also evading the country's tax laws, because we do know that, there's tax that needs to be paid to SARS if you've got people working on site.
That's true. I think one of the questions, for example, that comes into the picture in this scenario is that in terms of COIDA, every employer has to pay into the compensation fund every year so that employees, when they're injured at work, can then claim against their insurance. So one of the interesting questions that should come up here is the employer, whether it's their direct construction business or any of its subcontractors. The interesting question would be, have they complied with that the statute. I think more importantly, in regard of its applicability to foreign nationals, where either the employers have not paid that or they have, it's going to be an interesting legal conundrum to unravel as the investigations go through.
Yeah, there's been all manner of reports around how, the owners of the site are distancing themselves from what actually took place there. Part of the argument they make is that they actually hired contractors who in turn hired these workers themselves. But is it that clear-cut? I mean, can the people who own the site distance themselves from the disaster in that way?
There was a case decided in 2021 by the Supreme Court of Appeal. And essentially the principle that flows from that case is that as a primary, let's say for argument's sake, the owner of the building would then subcontract to a number of parties to then do certain work. That you have subcontracted does not take your responsibility away. So as an example, when you are constructing a mall, for example, and you have an instance where a portion of the mall is not secured from public access, and you then have slippery floors, and then one of the shoppers then walks past, slips, and falls, crack their bones or something. As the owner of the mall, you are responsible for that. You may argue that the cleaning company which you subcontracted to didn't do their work. Legally, that's neither here nor there. You still have ultimate responsibility. Your job as the owner of the premises is to make sure that the premises are safe. So that principle would apply in this instance. So it will be very difficult for the primary contractors, if you want to use that word, to effectively exonerate themselves from responsibility because they subcontracted somebody, and it is their responsibility to ensure that whoever they subcontracted to firstly has the requisite competence to do the work that has been subcontracted to them, and secondly that they comply with legislation. So it's the same scenario as employing employees without the right paperwork. It's still your responsibility to make sure that they have the right paperwork. If they don't, responsibility lies with them and not with the employees.
Yeah, absolutely. Look, we're speaking off the back of a number of assumptions, and that's only because there's still so much to be confirmed around exactly what happened and who was involved. But in many instances like this, typically we find that if it was foreign nationals working on the site and there were no formal documentation, there's a very high possibility that those foreign nationals are in the country without the requisite permits, work permits, etc., etc. What kind of legal principle will take precedent if that kind of thing were to be confirmed? In other words, does the court even care that people were there illegally before addressing the many other, possible human rights violations even that they faced while they were on site?
I think what you're most likely to have in this scenario is an intersection of a number of areas of law. I think the first bit, as we have discussed, is employment law. But the second area would then be immigration law in terms of ensuring that employees have the right paperwork. So as I said, a number of cases in our courts have said very clearly that you draw a clinical incision somewhere in terms of saying there is an injury at work. The injury affects a person, and the presumption is that in terms of either the Labour Relations Act or the Basic Conditions of Employment Act, the definition of employee is that the person is an employee. And along the way, then the issue comes up that they don't have the right paperwork. So the court generally take the approach that says, firstly, the obligation is on the employer to ensure that they employ people with the right paperwork. And that the employer failed to do so in this instance, firstly, does not exonerate the employer from responsibility. Secondly, it does not exclude the person from the protection that flow from the definition of employee. And thirdly, the presumption that the person is an employee applies unless it is rebutted, unless there's a number of things that says it shouldn't be applied in this instance. So the high probability is that regardless of whether or not the employees have the right paperwork, from an employment law point of view, when you then have the intersection with human rights as well as immigration law, is going to be such that protection has to be given to vulnerable employees, because generally in situations like this, the balance of power dictates that the employer would have a lot more power than the employee or the person or the foreign national that doesn't have the paperwork. So the fact that the foreign national doesn't have paperwork does not exclude the employer from liability.
Fascinating. Given what we know so far, and I suppose from your own experience, do you reckon there are grounds here for something like a class action lawsuit?
That may be one of the issues that flow. Remember, COIDA effectively excludes the possibility of employees suing the employer, because generally, if the employee were to, well, let's put it this way: if you didn't have COIDA insurance for employees injured or dying in the course of duty, employees and their families will then have to sue the employer. And you can imagine the cost of going to the High Court. Many of them would not be able to see the light of day in terms of the delivery of justice. So that piece of legislation was brought in precisely for that purpose. Now, in this instance, if this scenario arises that any of the foreign nationals, for example, do not fall into the definition of employee, in other words, the presumption that they are an employee does not apply to them, it then means that they can't claim the insurance benefits that sit in COIDA. But what it then means then is they have the right to then pursue a delictual action against the employer. And the test they will have to then prove is to effectively show that there was negligence on the part of either the subcontractor or the main employer, and whoever they decide to pursue their course of action against, they then have to prove negligence. And that may take a while, but it's certainly an option legally available to them.
All fascinating and so important. Galeboe Modisapodi, thanks very much indeed for speaking to us. Really appreciate your time on the SABC. Galeboe is an ER consultant with Molatudi Attorneys and Molatudi Advisory Services. Once again, thanks very much.